Recently, I have been thinking a great deal about just trying to disqualify one of the opposing counsels on a case that we are working on. That is because of their intimate involvement in the case, and I believe that it may directly impact a future trial and the testimony of some of the individuals that may be called to testify. I started thinking about disqualification of counsel, and randomly and perhaps fortuitously, a colleague of mine, Christopher Cast, who is one of the best mediators in all of Central Florida, has recently published in one of his weekly Facebook posts a fascinating case about the Florida Rule of Professional Conduct 4 3.7. Most of the Florida rules of professional conduct have a number that is not able to be memorized unless you are an absolute policy wonk and a total and complete expert. The case is known as Rivera versus Rivera Chong, a 2026 case. The decision was placed in the public record for LexisNexis and Westlaw less than a month ago. This is brand new law. Here is the summary from the District Court of Appeals. The former wife appeals an order disqualifying her lawyer. She argues that the trial court should not have granted the motion to disqualify, that the disqualification was based on speculation and not evidence. And guess what? Wouldn't you know it, the District Court of Appeals agreed with her. Here is the summary. This is a relatively short opinion. The two former spouses have been engaged in post-dissolution proceedings for years. In other words, motion for contempt, motion for enforcement, this and this and that and the other thing. At some point, former wife married her lawyer. Upon learning of the marriage, the former husband moved to disqualify the lawyer who married his ex-wife on the rule of professional conduct 4 3.7 on the grounds that counsel could not be counsel of record as he was a material witness in the case. The motion asserted that disqualification should be imputed to counsel's firm under Rule 4 1.10. Whatever. Who cares about the number? Just bear with me here. At the time, several pleadings were pending relating to time sharing with their children, parental responsibility, and school designation. At the hearing on the motion, the parties presented arguments, and of course, the trial court explained it was granting disqualification out of caution. The trial court explained it wanted to avoid a train wreck in the middle of a trial or before trial. Okay. The District Court of Appeals reviewed this case and they determined that a test of the disqualification quarter does be performed. When a lawyer may testify, a lawyer shall not act as an advocate at a trial in which a lawyer is likely to be a necessary witness on behalf of a client, unless there's always some kind of an exception in the legal field, especially in family law. The testimony relates to an uncontested issue. The testimony will relate solely to a matter of formality in which no substantive evidence will be offered. The testimony relates to the nature and value of legal services, or the disqualification of the lawyer would work substantial hardship on the client. A lawyer may act as an advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness. On the record before us, we cannot say that disqualification is required. The rule establishes that a lawyer may not serve as an advocate and a necessary witness at trial on behalf of the client. Here, the trial court's disqualification was not limited to counsel's representation at trial, and former wife maintained she had no intention of calling him as a witness on her behalf. I wonder what would have happened if the former husband in this case, and I'm not quite sure if he ever did, wanted to call the lawyer as a witness on his behalf. The record shows that while former husband would call counsel as witness, there you go, former husband offered no evidence that the testimony would be contrary to his client, let alone any evidence of the content of his likely testimony. A conflict requiring disqualification could arise if an opposing party called trial counsel as a witness and counsel's testimony was adverse to the client's position. A disqualification order granting broad relief was unfortunately not at issue here because nothing limited the scope of the disqualification to specific matters or phases of litigation for which counsel would be a witness. Let me summarize this entire thing for you. I don't think this resolved anything, actually, having read this a second time now. Admittedly, the first time I read it, I found it to be more of a headline oriented case, and now that I'm analyzing its substance, I realize that this resolved absolutely nothing. Because a broad disqualification here, I agree with the District Court of Appeals, could not be done, and they reversed. If I were the counsel on the other side, I were the one representing the former wife, I would probably go back to the trial court and then argue that the District Court of Appeals is in fact correct, that the broad order is something that could not be done. The broad order put a prior restraint. The broad order was too broad sweeping. And if I were counsel for the former husband, I would argue that that's correct. And now that we're going back to the trial court, we need to make it less broad. That's not my fault. That's what the trial court did in the first place. Your Honor, the District Court of Appeals is correct. And Your Honor is correct, except that the District Court of Appeals is now asking us to limit what it is that the other counsel is disqualified from testifying about. And that's fine. We totally agree. So here are the things that they should be limited from. And here's more specific evidence that should cause that limitation. It may require the filing of an amended motion for disqualification, which I do not believe is barred in this circumstance, and perhaps could be heard concurrent with the reverse and remand hearing, which is where the District Court of Appeals creates an opinion and sends it back. But again, the District Court of Appeals says that a broad disqualification order cannot stand. They didn't say that a limited disqualification order with more substance and more specificity cannot. This is interesting and perhaps a different kind of a lesson. And maybe the lesson to learn is if you are going to get into the business of marrying your clients, you may want to think twice about that.